an introduction about myself. I'm Kushank Sindhu. I'm from the batch of 2014, and I have worked earlier with, among other places, at ICICI Bank, Hyderabad, then with Luthra and Luthra, then with at the chambers of Mr. Adrian Rao, and also at the chambers of Mr. Pramod Dubey. And now I have a firm and a practice of my own, which goes by the name Sigma Chambers. So I'm here today, as the topic suggests, to primarily speak on what is the law on Benami in India. So apart from the other legislations that you have about in respect to your special offences, including the PMLA, so Benami forms part of the whole basket of those special enactments, which prescribe us sometimes a special procedure for handling special kinds of offences, because as we all understand, they are slightly technical in nature and it requires a different kind of understanding. So there is a fair amount of discourse and news around the Benami law in India. A number of names have been associated with it. You had, for example, VK Shashikala, you had Kuldeep Bishnoi, and all these cases, there was a lot of discussion about their Benami property, allegedly Benami property, and all of that. It is for this reason that an understanding of what is Benami law in India is extremely important. Or I would say not just a budding criminal lawyer or any criminal lawyer, but also anyone else who really wants to know how to enter into transactions which do not fall within the within the ambit of the Benami law. So you are protected from the same. And again, as I said, that understanding the same is very important, because Benami transactions as such have been in the Indian culture for a very long time, which I will just discuss through my presentation. As far as and I'll just be very clear about this, as far as the pedagogy for this seminar is concerned, I'm also trying to experiment with not having a PPT as such, because I'm sure all of us have had enough of a lot of PPTs in this period, and hence I will be just using my OneNote as a blackboard. So hopefully the idea is just to ensure that the concepts of Benami law in India, that is really clarified, because apart from that, then you can really understand how you want to either structure your transaction, or when there is a charge of Benami which is levied on you, how do you protect yourself from it, and also what exactly Benami law entails. So I'll just, yeah. So as far as I said, Benami property, Benami transactions are concerned, now let us look at a very basic example of what may constitute Benami, what may constitute a Benami transaction as per the law. Say, for example, that there is a house which is owned by an individual Y, and it has to be purchased by an individual X. A simple transaction, a simple commercial transaction would be that X gives money to Y and Y transfers the house to X. But say, for example, in the same transaction where the house is transferred to Y, rather it is transferred in Y's name, but the money for it comes from Z, and the house remains the same. In this transaction, this is what a simpliciter Benami transaction primarily looks like. This, as I said, it is a very simple definition, because as you understand it further, then you will see that it is not as easy as it looks, because there are a lot of complications, there are a lot of exceptions to what constitutes Benami transaction. So in this whole thing, there are 3-4 entities. One is the seller, the other is Y, the third is Z. Whereas this individual is the seller, Y is the person in whose name the house has been transferred, and hence he will be called the Benami Dar. Whereas Z is the person who is actually transferring the money, and in such a situation, usually what happens is that even though the house has been transferred in the name of Y, it is actually for the use and enjoyment of Z. And because of several reasons, Z does not want the house to be transferred in his name. Hence, because it is for the benefit of Z, that is why he will be called the beneficial owner of the property. So these terms are very important. Just to reiterate, the house has been transferred in the name of Y, but actually it is for the benefit of Z. Hence, Z is the beneficial owner, whereas Y is what is known as the Benamidar. Now, say for example, after this transaction has been entered into, where you have the seller and you have Y who's known as the Benamidar, and then Y transfers the house to T, and T in exchange gives money to the Benamidar. So here, not just the house, this is obviously Benami property, but also this money will constitute what is known as Benami property. So this is something on the lines of what is known as, in certain legislation such as PMLA, it is known as proceeds of crime, or any proceeds basically, not just proceeds of crime. Because proceeds of crime has a slightly technical meaning when it comes to the PMLA, etc. So just to make it very simple, that any proceeds from the main Benami property, which is this, will also fall within the definition of what is Benami property. There might be other situations where the property has been transferred from, and this understanding has developed not just from the main statutory act, obviously the Benami Transactions Prohibition Act, but also from the case law which has developed from the legislation. Now, as far as the law is concerned, it is included in the act, which is a pretty self-sufficient act. There were major amendments that were brought about in 2016, and then also recently there have been certain amendments. So when you look, this entire understanding is depending upon the act, the law, the notification, all of them which have come out from the government. Now, the property may be transferred from X to Y, and this can be for Z in this example that we have taken, where he is the beneficial owner and he is the Benamidar, where this property has been transferred for the benefit of Z. Now there are 3-4 things. One is that it can be either for the immediate benefit or it can be for future benefit. Apart from the same, there can be situations where Z wants to purchase the property, but he asks X to transfer the property in the name of Y. But Y is actually a fictitious entity. There is no one by the name of Y. It is just an entity. They are just, say for example, Z has forged some identity. Z has forged Aadhaar card details. Z has forged the PAN card, and he has gotten photos from Photoshop photos, and then said that okay, the property has to be transferred in the name of Y. That Y is a fictitious entity. There's no one by the name of Y. Even then, it will be a Benami transaction. it is not necessary that Y has to actually exist as a person. The other situation might be where the property has been transferred in the name of Y, but Y does not even know that the property has been transferred in the name of Y. There were certain cases where, when it came to these government schemes and all, the money had to be directly transferred in the account of the in the beneficial owners. But actually, what happened was that the money went into certain other accounts, and the third party account holders did not even know that the money has come in their account. So even then, where the person is actually not aware of the transaction, even then it would be a Benami transaction. And the last, subclause of a Benami transaction is where the property has been transferred to Y, the money has come from some person, but we do not even know who this Z is because he is untraceable. So this is a catch-all kind of provision which also is included within the definition of Benami. There is a commonality that exists among all these transactions, and that is that there are a lot of permutations and combinations when it comes to understanding a Benami transaction. It can be for different purposes. It can be between different kinds of entities. Hence, practically speaking, there cannot be a set standard. There cannot be a set standard. A set standard does not really exist because a judge has to look at not just what is there in the act, but also what is the real intent of the parties. What is the nature of parties? What is the relationship of parties? All these considerations have to be borne in mind. But why is this so? This is because Benami transactions in India has been part of Indian culture for a very long time. Say, for example, there is a family with X and Y and Z as children. Many a time, the same house, can be transferred in the name of Y, but the money, house is transferred here, the money is paid by X, because X being the father, he wants to pay money. And by the way, it can be father or mother, or similarly son or daughter. I'm just saying father and son for the sake of clarity and for the sake of convenience. This kind of transaction may not be included and will not be included as per the act under what is known as a Benami transaction. Why is that so? Because transactions of such nature where there is a lineal ascendant or lineal descendant may be excluded from the definition of Benami. Now that we have some sort of an understanding of what constitutes a Benami transaction, it is important to understand, and as I said before, that Benami transactions have been part of Indian culture for a very long time. But it was slowly and gradually realized that the problems which arise from these kinds of Benami transactions really sort of far outweigh the benefits that can accrue from allowing these kinds of transactions. And hence it was decided that there was a law commission report. There was and then the 1980 Act, this Act came, 1988 Act came, and then the 2016 amendment came, and the amendment and their notifications thereafter, because obviously the benefits far outweigh, the costs far outweigh the benefits. Now, if such a transaction has been entered into, and you will see when it comes to criminal law and the practice of criminal law, that it is actually the process that follows this whole transaction, which is where you have a fair amount of litigation and confusion which arises. Now, In this kind of a transaction, the first thing you have to understand is that Y cannot file a suit against X for, say, specific performance. That cannot be done in this kind of a Benami transaction. That is very clear. Apart from this, there is a concept of attachment and confiscation of the Benami property. Now, this process is very important because, as I said, a number of people have received notices. And if I can give you some statistics, as per data which was provided in the Lok Sabha, till 31st December 2018, the income tax authorities had identified more than 2,000 Benami transactions. And this is not just land, this also included deposits in bank accounts, plots of land, flats, jewelry. Attachment of properties was undertaken, provisional attachment, in over 1,800 cases. And the value of the properties which were attached was to the tune of more than 6,900 crore. Hence, this process is very important because this is, I would say, the meat of the matter, and this is where the major part of the litigation comes in. So the entire process of attachment and confiscation begins at what is known as the initiating officer. At his level, the attachment and confiscation process actually initiates. Now here, these people are generally part of the income tax establishment, and as the rules suggest, they are of different ranks: assistant commissioner or deputy commissioner, as defined under the Income Tax Act of 1961. Say, for example, in this situation, the initiating officer comes to know about this transaction. Now, this information cannot be just any information that is brought to the notice of the initiating officer. It has to be material information, meaning thereby material. It has to be based on some sort of material which may or may not include some sort of documents. So if he comes to know, and if he has some material, for instance, documents which gives him a reason to believe. Now, this term is very important, reason to believe, because this should not be a mere guess or a conjecture. This reason to believe is extremely important because at a later stage you can have, this can be one of the grounds for challenging the attachment process, that there is no reason to believe that this has happened, and the initiating officer has actually gone ahead with this process merely on his whims and fancies and guess and conjecture. So this is very important even from the perspective of the prosecution, from the perspective of the department, to ensure that there is some cogent material on the basis of which this entire process has been initiated. Now what he can do is, after he has reason to believe that such a Benami transaction has been entered into, he can issue a notice. And this notice is very important because this is in the nature of a show cause notice. As per the show cause notice which he gives, he will give it to the individual, which he will give it to both the beneficial owner as well as the Benamidar. And again, many a time it so happens that the beneficial owner is not actually known. So it obviously goes to the Benamidar who can be identified, may be identified. Now this is a show cause notice which is given. Now this is again very important because it is not always that a show cause notice has to be given. He can undertake what is known as a provisional attachment. Now this provisional attachment is on the lines of what is there even under the PMLA, that is the Prevention of Money Laundering. Why am I making this reference to PMLA is because these acts usually in practical this thing go together. The Benami Act, PMLA, etc. And also, if you do a lot of these prevention of corruption cases, etc., they're all part of the same basket of cases. And many a time, even the judicial officer is the same who is dealing with PMLA cases as well as the Benami Act cases. Now, but before the provisional attachment is undertaken, he has to take prior permission. And this prior permission from his senior authorities is very important because this is a safeguard which is given. And again, because of non-fulfillment of any of these procedural safeguards, you can make out a case for challenging your attachment. Now, this is also very important, a provisional attachment, because there might be a situation and there might be a danger where the property can actually be alienated by the individual who comes to know about the investigating authorities and agencies going after him or her. It is for this reason that this safeguard has been introduced in the legislation. Now, the concept of provisional attachment is also important because it can be undertaken for a maximum of 90 days. Now, when does this 90 days start is obviously when you have your attachment, the initial attachment order which is passed. But later on, there can be a situation that the 90-day period keeps on extending because, and this is extending as and when the adjudicatory process and the process before the appellate authority is going on, then this situation can arise. And this, in my view, the Act does not really take care of this situation. Now, as far as the after the provisional attachment order is passed, there is a step of confirmation which is undertaken, and after this confirmation has been done, then you have the adjudicating authority and the litigation that happened before the adjudicating authority. Now, there might be a situation where there is no provisional attachment, and which is basically this, where there is just a show cause notice which is issued. In this situation, after the show cause notice is issued, the proceedings are undertaken before the initiating officer. And if the initiating officer decides that the attachment has to continue, or the attachment has to be made in this situation, in the first situation, the attachment will have to be made, then a statement of case is drawn up, and the matter goes before the adjudicating authority. Now, when the matter is before the adjudicating authority, he has to issue notice, and this notice is issued within, it has to be issued within a period of 30 days from the date of receipt of the reference. And this notice will have to be issued primarily to 4 persons. And that is the person who is specified as a Benamidar, which in this example would be Y. And if the beneficial owner can be traced, then even to the beneficial owner. Now, there might be situations where money for the transaction has actually come from a bank. And this also I will be covering because there is case law to the effect to avoid, a bank and a loan being issued and where the bank actually transfers the money directly to the seller or a third person. That does not fall within the definition of Benami. So anyway, the point being that in such a situation, a bank may also be an interested party, and even the bank has to receive a notice by the adjudicating authority. Now, before the adjudicating authority, the process that usually happens is the same as is conducted before any standard, adjudicating authority or a standard court, even if they are not strictly a court in the strictest sense of the word. The reply has to be filed and then the hearing has to take place, etc. But what I would really like to focus on are two, three things, and that is the time limit. There is a time limit of 1 year that has been prescribed for the conclusion of these proceedings. Now, after the proceedings have been concluded, then the adjudicating authority can proceed with what is known as the confiscation of the property. And after the confiscation order has been passed, the order of confiscation can be challenged before the appellate authority. Now, this is very important. But before we go on to the appellate authority, let us look at what is the confiscation stage and how that happens. When the order is made of confiscation, all the rights and title in the property, say for example, this is the property, this earlier where it was from X to Y, now the house is actually transferred to the central government. The house is transferred to the central government. And the entire confiscation proceedings is undertaken by the administrator, who is especially appointed for this process. Now, as I said, you can challenge the confiscation before the appellate authority. From the decision of the appellate tribunal, you can, sorry, this has to be tribunal. You can challenge the order of the appellate tribunal before the High Court, having jurisdiction to having the territorial jurisdiction over your matter, over your property, wherever it is situated. Of course, the jurisdiction will be determined by the will also be determined by the local High Court rules, etc. But as far as subject matter jurisdiction is concerned, the appellate, it is very clear that the appeal goes to the High Court. Now, apart from this, Article 226 is again very important. A writ can always be filed, and as I will discuss when it comes to the practical application and the way in which the courts have been interpreting the legislation, there have been several cases where writ proceedings have been challenging different stages, and the court has to play a very balancing kind of act, because say for example, when we were talking about the provisional attachment order, the provisional attachment order, you can obviously pass it. If you do not pass it, there is a danger that the property will be sold. But if you pass it, can your rights of someone who is staying in the property be affected? Say, for example, there is a tenant in the property and you have an attachment process which is going on. There was one case which was filed, I believe, before the Chhattisgarh High Court, where they had said that my rights will be affected if the provisional attachment, and this was, I think, it was the tenant who had filed it, that if this kind of an attachment order has been passed. Now the question was that, can this continue? And this is where the court said, because these are all cases which have been arising only right after the amendment. So the understanding is yet to develop of how to deal with these situations. The court said that there has to be a balancing act that the court has to play. That is to ensure that there is no irreparable loss which is caused to the department if the property is sold, or there is no irreparable loss which is caused to the third party if the attachment order is passed. So then what should be the extent of the attachment order if it should be passed? So these are the considerations, and which is why your Article 226 is extremely important. Now, apart from the statutory proceedings which can go on, the question is entering into a Benami transaction a crime? The Act says that basically a complaint can be filed under the Act for violation and for any offense under the Act after getting prior sanction from the Central Board of Direct Taxes. After the sanction has been received, then uh, and then basically a complaint can be filed under the Benami Transactions Act. Now, as I said, entering into a Benami transaction has been part of Indian law and frankly a part of Indian culture for centuries. There were British cases also in which people had entered into these transactions, and the court said that it's not just because someone else has paid for your property, it does not necessarily mean that some kind of loss will be caused, and which is why I said that there cannot always be a set standard, even though the statute provides for the definition of Benami transactions in slightly wider forms. But the statute also provides for certain defenses because it recognizes that there are certain limitations and there are certain uh, aspects of Benami transaction which are distinctly part of Indian culture. So the first defense that you can take when it comes to a charge of Benami is that you had entered into a transaction as a part of an HUF. So basically the Karta had purchased the property for the benefit of the other members of the HUF. This is a situation where you can take the defense of, and this can be an exception to a charge of Benami. The other part is that if someone is in a fiduciary capacity and then you are entering into this transaction, in such a situation also you can take the defense of to the charge of Benami transaction. But now the point is that what constitutes fiduciary capacity, and this also depends. And as I said in judgments, also the courts have undertaken this analysis in different form. But usually, what happens is that if there is a trust, so a trustee is if there is a trustee, and then that person is in a fiduciary capacity for the person in whose benefit the trust has been created, or you can have an executor of a will, even they can be protected. Then you have a partner, even they can be protected. The other aspect is a director. So it can be argued that the director is also in a fiduciary capacity, and again, as with every other thing in life, we will have to look at it from the depending upon the facts and circumstances of the case. The other way is, as I said, your lineal ascendant or descendant, and then it may be brother, sister, spouse, children, etc. Now, there was one example which I had told you that in these situations, obviously, especially when it comes to property transactions, you also have a bank which is operating. Now, naturally, I would say that when there is a situation where, say, for example, in this case itself, where the money here, the money has traveled from Z to X, and Z here is a bank. then obviously in these situations, I personally don't feel that this can fall under the definition of Benami, because these transactions are very normal. So strictly speaking, it would probably fall in a very strict and, so to speak, positivist understanding. But this would lead to a very haphazard kind of situation, and obviously this kind of an analysis has to be avoided. Now, in the same transaction, here Z is not always an individual. Z can also be a company, say ABC Limited. Here also the Act provides, covering these situations, that ABC Limited as a company may also be held liable apart from the directors, officers, etc., who were in charge of the transaction and who had actually initiated the transaction. It has the Section 62 of the Benami Act as a very clear kind of definition, a very classic definition of corporate liability for entering into these transactions. Now, I have done a study of the judgments, etc., especially arising out of my practice, of how the courts have been dealing with Benami transactions. And when I look at the judgments, the first thing that I see is that there is a lot of challenge which has been made to the provisional attachment order. Now, here, understand one thing. In the initial steps, we had discussed that there are two ways. That one is the you have a show cause notice, and the other you have a provisional attachment order. And there have been situations where even before your provisional attachment order has been passed, there have been certain authorities who have actually gone ahead and asked for some information. Now, if the authority has not adequately considered the response to your notice, the provisional attachment order can still be challenged. And this is also arising from some of the judgments which have been passed. Apart from this, as I said, you can file a standard 226, you can file a writ at any stage, and this is the usual process which is followed. And again, as with any other circular, you can challenge it for lack of jurisdiction, you can challenge it for non-application of mine, you can challenge it for irreparable loss which may be caused. Now, as far as the judgment that I was talking about, you can have a note of this judgment, which I feel is important, that this is Sonamura Foreign Liquor Shop. Foreign Liquor Shop. And the citation is Manu GH. I'm not using the SEC or the AIR citations because I just feel people can just, students especially can just go on the Manpatra and pull out this judgment. Here also the judge had said clearly that you have to sort of weigh the pros and cons of allowing this kind of provisional attachment, because on the one hand, irreparable loss can be caused if you actually go ahead with the provisional attachment, or on the other, irreparable loss can be caused if the property is not attached and it is immediately transferred and immediately sold to a third party. The other aspects that I have seen from the judgments, the trend of judgments, basically what has been passed by the courts, and that is that whenever they look at your writ petitions, there are a few things that they always look for. And the first thing that they look for is, and this is very important because, again, as I said, you might get a lot of cases where you have to challenge the notifications and the attachment orders. You have to clearly spell out the prejudice which is being caused. And you have to make out a specific case with as specific example as possible as to why you need the attachment order to be set aside and what is it that you're trying to achieve. The other aspect which is very important is that whether the amendments apply retrospectively. So It is a retrospective application of the 2016 amendments. Now, once you analyze the legislation, you will see that as far as the amendments go, 2016 was a pretty, I would say, a landmark year. It was a watershed year when it came to Benami Law, because the act as such was entirely almost amended. So it was a watershed year in many respects. Now the question is whether or not it is actually retrospective in nature, and this has also been the subject matter of different legislation, different cases before different courts. As far as the latest position goes, if you look at the judgment of Union of India versus Ganpati Dealcom, the order dated 3rd Feb 2020, the Supreme Court has basically stayed the order which was passed by the Calcutta High Court in 2019, on 12th December 2019, where they said that the amendments were prospective in nature. So this has been stayed, and the court is still seized of the matter. Different high courts have also had different kind of views on it. You had Rajasthan High Court in the case of Niharika Jain saying that the 2016 amendment applies prospectively. Then you had Madras High Court also saying in October 2019 on similar lines, and then you had the Chandigarh Appellate Tribunal, which retrospectively applied the amendments to a transaction that was entered into before the amendment came into existence. So, having said so, I'm just saying that there has been a very consistent sort of, the courts have been going consistently back and forth on this issue, and it's still the subject matter of litigation before the Supreme Court. And frankly, I would say that as law students and as law people, it is important for us to analyze these legislations and see whether or not it should actually be prospective and retrospective in nature. And what I really hope from this webinar is that at least students of law have sort of realized that even apart from the IPC and CRPC, and I have been following the other webinars also that have been conducted by the NALSAR Alumni Association and the Nyaya Forum, there are a lot of special legislation also that any criminal lawyer has to know. And especially as students of law, it is important for students to be abreast of these developments, because these are still happening, and these are very important judgments which, whenever they come, they will really clarify the law on these aspects. So I really hope that this webinar has been useful for students, and I really wish that we have more interest among students to pursue a career in criminal law. So I would like to end my webinar with that. But apart from this, if there are any suggestions, questions, please feel free to let me know.
Thank you so much, sir.
Right. Thank you so much. And my email has been exchanged with the NALSAR Alumni Association. If there's anything else that you guys want me to cover or let me discuss, please do. Thanks. Thanks so much.
Yes, sir. Thank you. Thank you.